let's take a look at pre-employment investigations. The cardinal rule for pre-employment investigations is that they must be job-related. Employers should not inquire about personal matters such as marital status, the willingness of a working spouse to relocate, or if the person has children, because these questions are not germane to the candidate's ability to perform the job. Once a hiring committee crafts its questions, how can it ascertain if the applicant answers them truthfully? Scientific tests are alluring, but the Employee Polygraph Protection Act of 1988 restricts the use of polygraph tests due to concerns about the technology's accuracy. Private businesses rarely are authorized to use such tests. Public agencies are exempt from the act, but the law does not preempt state or local regulation, and about half of the states have enacted an anti-polygraph statute. Even when testing is not prohibited, it has been challenged in court with success. Some organizations seek to refine the hiring process by using personality and psychological tests, such as the Myers-Briggs Type Indicator, which provides information about decision-making styles and interpersonal interactions. If a test is considered a medical exam under the Americans with Disability Act, it may not be administered until after a conditional offer of employment has been made. Medical testing of public sector applicants is usually done to detect drug and alcohol use or the presence of communicable diseases. Post-offer but pre-placement medical exams are permissible and need not be job-related. An emerging concern is the use of genetic testing for illnesses that might affect job performance, such as Alzheimer's disease. The Genetic Information Non-Discrimination Act of 2008 prohibits employers from discriminating on the basis of genetic information. Does an applicant's financial history reveal whether the person will be a dependable, trustworthy employee? Perhaps, but Congress enacted the Fair Credit Reporting Act of 1970 as amended in 2003, in part to prevent employers from using inaccurate or arbitrary financial information. To obtain a credit report on an applicant, the prospective employer must ask the applicant to authorize one. Before taking adverse action based on the credit report, the employer must provide the applicant with a copy and advise him or her of their legal rights. Applicants' criminal history records are important to public employers. The paradox is that about 92 million people, or 1 in 3 adults, have criminal records. Deciding what to do about criminal records reveals a specific policy choice. Governments may disqualify persons convicted of certain crimes, like felonies, for certain jobs, either permanently or for a set period of time, or they may consider each applicant's situation individually, which is best practice and advisable.